Hi friends, Commissioner CBIC issued a circular number 183 dated 27th December 2022 in which clarifications produced with respect to difference in ITC availed in Form GSTR 3B and GSTR 2A. This is applicable for the financial years 2017-18 and 18-19. It was a fact that Form GSTR 2A not made available to the taxpayers on the common portal during the initial stage of implementation of GST. There was mismatching between GSTR 1 and GSTR 2A, and there was also restrictions regarding availment of ITC were provided under Rule 36(4) of CGST Rules 2017. But it was made effective from 9th 2019 onwards. Further restrictions also specified in Section 16 of CGST Act from 1st July 2017 itself. However, after considering the various representations from the trade and tax authorities pertaining to above this mismatch, now this circular gives a uniformity in the implementation of provisions of law in exercise of the powers confirmed under Section 168(1) of CGST Act. There are 4 different scenarios to be considered as per this circular. Situation number 1. Supplier failed to file GSTR 1 for a tax period but already filed GSTR 3B. Situation 2. Supplier filed Form GSTR 1 and also GSTR 3B but failed to report a particular supply in GSTR 1 so that it is not get reflected in GSTR 2A of the recipient. Situation 3. While filing GSTR 1, supplier wrongly reported the supply as B2C instead of B2B, so that Form GSTR 2A will not be get reflected the same. Situation 4 is where supplier filed GSTR 1 and GSTR 3B for a period but declared supply with a wrong GSTN of the recipient in Form GSTR 1. In all the above 4 situations, this circular now made a clarification, and I would like to share with you that details also. Proper officer shall verify the eligibility of ITC between GSTR 3B and GSTR 2A, and also shall ensure the conditions satisfied under Section 16 of the CGST Act. As we know that he is in possession of tax invoice, debit note or such other tax paying documents, he has received the goods or services or both, he has made payment of amounts toward the value of supply along with the tax payable. Moreover, now officer shall check whether any reversal of ITC is required to be made in accordance with the Section 17 or 18 of the CGST Act, and also complied with the Section 16(4), that is specified period within which ITC to be availed. In addition to this, now while verifying the conditions in Section 16(2)(c), officer may be taken the following action. 1. If difference between ITC claimed in GSTR 3B and GSTR 2A of registered person in respect of a supplier for the said financial year, not month-wise, exceeds 5 lakhs, officer shall ask them to produce a certificate from the chartered accountant or cost accountant certifying that the supplies in respect of said invoices actually made by the supplier and tax on such supplies has been paid by him in the return of GSTR 3B. Besides, such certificates issued by chartered accountant or cost management accountant shall contain the UDIN also. Situation 2. In case where the difference between ITC claimed in GSTR 3B and GSTR 2A for the said financial year is less than or equal to 5 lakh rupees, a certificate from the concerned supplier only need to submit. That is, a self-certification will be the solution. The most important condition for the financial year 2017-18 is that such a taxpayer has to file GSTR 3B, GSTR 1 on or before the due date of filing monthly return of March 2019. It means Section 16(4) proviso has to comply with. Therefore, if a taxpayer not done as stated above, such supplies are not eligible for this benefit of the circular. This circular will apply only to the ongoing proceedings on scrutiny, audit, investigation, etc. for the financial year 2017-18 and 18-19 only. And also it is not to the completed proceedings. However, this circular will apply where any adjudication or appeal proceedings are still pending. In short, several notices issued by GST authorities regarding the mismatching and discrepancies in the scrutiny of return shall now come to an end after this circular. And recently, Karnataka High Court, given in a repetition in the case of Wipro India Limited, made a direction to the GST authorities even for the third financial year. That is, in addition to 2017-18 and 18-19, court has given a direction to the GST authorities to verify 19-20 financial year also based on the same circular of 183. These are the important points to be remembered under circular 183. Thank you very much for watching this video. Bye.